Hello, everybody, and good afternoon, and welcome to our program entitled The Impact of California Civility Rules on Litigation and ADR, a very interesting topic indeed. I'm Robert Cohen, Chair of the Beverly Hills Bar Association Mediation and ADR section, and I have the privilege of introducing today to you two terrific panelists. The first is the Honorable Yvette Palazuelos, and I hope I said that right, Paulette. And if I didn't, you'll correct me.
That's okay, Palazuelos.
Palazuelos. Okay, thank you. And the second is Attorney Alan Petlak. And both Judge Palazuelos and Alan are very experienced in terms of trials and litigation, and they've been through the wars over decades, whether it was in the federal courts or in the state courts. Now, Judge Palazuelos first joined Judicate West this year after 24 years of service on the Superior Court bench. She was appointed in 2000. Initially, she presided over a wide variety of civil matters while sitting in an individual direct calendar courtroom. Then, in 2018, she was assigned to preside over complex civil cases, such as mass torts, class actions, and complex business disputes. Prior to her appointment to the bench, she was an assistant U.S. attorney prosecuting federal criminal matters in the Central District. Alan has a different background. He's been a full-time mediator since 2018 and an arbitrator as well. And since 2022, he's been on Judicate West's esteemed roster of neutrals. Prior to becoming a neutral, Alan spent over 20 years as a big law litigator and trial lawyer, handling a variety of civil disputes from intake through trial. Alan has expertise in real estate, personal injury, consumer finance, employment, and securities law, and has litigated many complex business disputes over the years. He is always prepared for any assignment that he takes on, and he is quite successful in bringing matters to settlement by utilizing his special problem-solving techniques and his years of litigating and trying a multitude of cases. So Judge Palazuelos and Alan, the floor is yours, and I look forward to being in the audience and hearing what you have to say. Thank you.
Thank you so much, Robert, for that very nice introduction. We have a lot of material we intend to cover today. If we have time at the end, we will take some questions. But it's a very broad topic when you speak about civility. It's something that has been in discussion through the judiciary and litigators and transactional attorneys from I think from the beginning of practicing law. And it's taken on a renewed focus over the last few years. In 2021, there was a report that came out from the California Civility Task Force, which was a joint project of the California Judges Association and California Lawyers Association. And they came out with a number of proposals to really stress the importance of practicing law with civility. There were a number of proposed rules, which we will discuss. Some of them have passed, some of them are still pending. Among one of the rules was to require an annual oath for lawyers on a going forward basis, making clear of their obligation to be civil. This actually stems from the relatively new requirement. It's new for me because I became a member of the bar back in 1995, but in 2014, the California Rules of Court 9.7 was adopted, and 9.7 requires all new admittees to take an oath that says, as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. It's also true, and I know that we have many in attendance today, and I'm happy to see it, that it's now an MCLE requirement that you take 1 hour of civility training, beginning compliance period January 31, 2025. And I will tell you, since that's been adopted, this is now my third presentation on civility that I have given. But it's sort of the emphasis of part of the skill, part of being a good advocate for your client is also demonstrated for your client the importance of civility in the practice of law. I'm going to turn it over to Yvette now to talk about some of the proposed rules, including what's affectionately called as the snitch rule. And one of the things that is being proposed is that a lawyer may be disciplined for not being civil. So Yvette, let me turn it over to you.
Well, thank you, Alan. Yet the State Bar has proposed a new rule, 8.4.2, based on recommendations of the California Civility Task Force, and Alan just described what that task force was. And this rule provides that a lawyer may be disciplined for incivility. That was kind of surprising to me that there wasn't such a rule to begin with, but in fact there isn't. And this rule is under consideration, hasn't been passed. We're going to talk about the text of it, but realize that what we're presenting today is not the final rule. It could be amended. In fact, it could be entirely rejected, but it could be amended or changed in some fashion. But we're going to talk about what it looks like now. So this is the new proposed rule 8.42. It's labeled prohibited incivility. In representing a client, a lawyer shall not engage in civility in the practice of law. And for purposes of this rule, incivility means significantly unprofessional conduct that is abusive or harassing, and shall be determined on the basis of all the facts and circumstances surrounding the conduct. So the key question now is, what is unprofessional conduct that is abusive or harassing? So we have some guidance is provided for us in the comments to the new rule. For example, comment 1 says, for guidance on the conduct that may be significantly unprofessional, that is abusive or harassing, lawyers should consult the current California Attorney Guidelines of Civility and Professionalism and other relevant authorities. Those other relevant authorities would be case law, for example. We're going to talk about the case law later, so you can get a sense of what courts have determined to be significant incivility. But you should consult the guidelines as well as case law, and in the local rules of court and bar associations, codes of civility. Now, we have provided in the materials for this seminar, the LA Superior Court guidelines for civility. They can be found in local rules under Appendix C, but we provided them today as part of our materials. That can also inform you as to what is unprofessional or abusive, harassing conduct. Also, comment to new rule 4 defines incivility as a rule that may include conduct or speech that violates an attorney's duties under the Business and Profession Code. But what I found really interesting about this comment is its reference to the California Judicial Code of Conduct. As you can see, Canon 3B says, regarding a judge's responsibility to require lawyers under the judge's direction and control to be patient, dignified, courteous to litigants, jurors, witnesses, lawyers, and others. So that's telling you what the rule expects of civility, patience, dignity, and courteousness. And it also makes sure that you understand that your civility is expected for all these parties in the process, not just opposing counsel, but litigants, jurors, witnesses, and the court as well. So it's not just confined to opposing counsel.
Let me ask you a question, because that sort of strikes me. When it says that one of the obligations is to be patient, and unfortunately, as a mediator, I'm very patient. Outside of being a mediator, I probably am less patient than I should be. But the setup to this point is the fact that it's a possibility that one day having a lack of civility may be subject you to discipline. Can you really be subject to discipline for being impatient?
You probably could, but interestingly enough, in the context of mediation, you will see that there's a privilege associated with mediation, as you know, and therefore incivility that may occur in the context of mediation may be privileged. And that will come up later in the presentation, but it's interesting that you do raise that as a possibility. But yes, patience is required of all of us, of the mediators, of the participants in the mediation, but the privilege attached to it would probably make that not reportable, but we'll get into that later. All right. This is what we call lovingly the snitch rule, the California Rule of Professional Conduct 8.3, and that is actually a rule that's in effect. It's not proposed, it's in effect now. And that provides a lawyer shall, without undue delay, inform the state bar or a tribunal with jurisdiction to investigate or act upon misconduct when the lawyer knows of credible evidence that another lawyer has committed a criminal act or has engaged in conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation or misappropriation of funds or property that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. That's quite a mouthful. So what I did in this next little slide here is try to break that down a little bit. So what the rule requires, the snitch rule requires, is that attorneys report the following type of misconduct by fellow attorneys. Criminal acts, of course, and that probably as a result of Thomas Girardi, unfortunately, in that situation, the criminal acts would have to be reported by attorneys against fellow attorneys to the state bar. Also, conduct including dishonesty, fraud, deceit, misrepresentation, misappropriation. But the last part is what I find very interesting. This is kind of the catch-all for reporting. Conduct involving a substantial question as to the attorney's honesty, trustworthiness, or fitness as a lawyer or as an attorney in other respects. And that's where we have the sort of the meeting of the 8.3, the snitch rule, and this incivility rule.
I have a question for you. So what happens if you don't snitch? So if you see that conduct, choose not to report it, what's the consequence?
That could be disciplined by the bar. I mean, that's why this first little sentence here, we say it's a violation of the ethics rules for lawyers to fail to report or snitch on fellow lawyers. And so what that means for our incivility rule is since misconduct includes conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness, the lawyers likely must report significant incivility to the state bar. So that's the impact of kind of marrying those two rules together. So what does a substantial question of significant incivility mean? Well, I think, and then this is going to have to be developed over time, obviously, but we're not talking about garden variety rudeness, okay? It requires something much more than that. And the definition of substantial in Rule 1.0.1L says, substantial when used in reference to degree or extent means a material matter of clear and weighty importance. So the garden variety rudeness would not be part of the incivility that would be reportable. What they're talking about is severe or substantial incivility, and it would not be, failing to return a phone call, right? That's rude, yes. It's not appropriate, but it happens, but it wouldn't rise to the level, at least in my view, of substantial and significant incivility. But we'll go through the cases later. Alan and I will go
question for you on that. I mean, isn't it sort of still a slippery slope? Because what I think is very offensive may not be what you think is very offensive. And then you have to decide what's reportable and what isn't.
Yes, they're very true, which is part of why I said this aspect of the rule is going to have to be developed. And hopefully, I would like to see from the civility task force, maybe like examples, maybe a sheet that would give lawyers examples of what would constitute substantial incivility, as opposed to this garden variety type rudeness. We're not there yet, Alan, but you raise a very good point. This is something that's got to be developed over time. There's a comment to the Stitch rule, comment note 6, permits reporting to either the state bar or a tribunal with jurisdiction to investigate or act upon such misconduct. So you actually have to make a determination. Do I report it to the state bar or should I report it to the tribunal? Now, if you have a case you're litigating in, the IC court, for example, and you have some kind of incivility in discovery, obviously you can bring that to the attention of your trial court, and that will be taken care of. If it can't be taken care of by the trial court for some reason, then you would report to the state bar. But there's an interesting note, paragraph in note 6 that deals specifically with arbitration. It states, however, where the litigation is pending before a private arbitrator, reporting to the tribunal may not be sufficient. A determination whether to report to a tribunal instead of the state bar will depend on whether the misconduct arises during the pending litigation and whether the particular tribunal has the power to investigate or act upon the alleged misconduct.
Let me ferret that out a little bit more. So if you are before a superior court judge, like you were once a superior court judge, and there is severe misconduct by the other counsel, then in that respect, you'd be permitted to report that to the judge, because the judge could potentially then investigate it and come to some sort of findings. Is that right?
That's correct. Either through, for example, in a discovery issue, either through a motion to compel discovery with requested sanctions or just a request for sanctions. You could do that as well. Also, Alan, another thing that I think could be done is a status conference. Just set the matter on for a status conference. You don't even have to bring in a motion. Just ask the court to set a status conference and kind of alert the court to the problems. They could be kind of worked out in that way. That's another possible avenue that a trial court or a tribunal could address it. But in the context of arbitration, the tribunal, the arbitrator, has limited powers. So, for example, here, if the incivility is outside the litigation, does the arbitrator have power to address it? I don't think
Probably
so.
not. Right.
No, and that would be a circumstance where you'd have to report to the state bar, because the tribunal, the arbitrator, cannot address the incivility. For example, if you're doing an arbitration concludes, maybe it settles, for example, maybe 2 days into the arbitration, you settle your arbitration. So, but after it falls up and the arbitration is dismissed, then for some reason the parties get in dispute over the settlement, and it starts to be some incivility among the parties in that context. Would the arbitrator be able to jump in at that point? No, because the arbitration has been dismissed. You settled your case. That's outside the power of the arbitrator. So that would have to be addressed to the state bar. However, if your trial court somehow still maintains jurisdiction in some fashion, even though the arbitration was dismissed, perhaps that can be brought to the attention of the trial judge.
Let me ask you this question, and I think it's probably a question without an answer. What if your arbitration agreement provides that the arbitrator has the same authority as a superior court judge? Would that make a difference?
I don't know the answer to that. That's a good question. I really don't know the answer to that. That would have to be tested, I think, in the courts in some fashion. I would assume if you had the same power, you could. I don't know if an arbitrator would really want to do that, but I'm assuming if you have the same power, you could. But I think that would have to be tested, Alan. I don't have the answer to that.
Certainly an appellate issue.
Right. And the second little PowerPoint there about arbitrators do have power to act, obviously, within the context of the litigation, motions to compel and sanctions in connection with that for incivility. Also, reduction for attorney's fees, that comes up in arbitration. That could also take care of any kind of incivility. So there are powers, times when the arbitrator can address incivility. So that would not be required to be reported to the state bar. That could stay right with the arbitrator. But I also noted here, there are some powers that I think, and Alan raised that just recently, I think the arbitrator would be limited. For example, if there's a severe incivility warranting contempt, is that something an arbitrator can impose? I have doubts about that. The reason being, arbitrators are given power to decide civil disputes. We know that contempt is kind of a quasi-criminal type of proceeding. Is that really something that was given to an arbitrator to do in connection with this civil matter? I have doubts about that. But again, this is something that can be explored later. But it raises an issue whether that really is if incivility is so severe, it would result in contempt. Is that really something that an arbitrator can take care of? I doubt it.
It's a great point. It's the fact that you get in the land of criminal, and that may impact the authority of the arbitrator to really act.
And same thing goes for removal of counsel for incivility. If it's so severe that counsel should be removed for incivility, and we'll see later on, there's case law about that. That's not something an arbitrator typically does. That probably would be reserved for the state bar. So that would be a circumstance where you wouldn't necessarily report to your arbitrator, but would report to the state bar. Or
I believe we had a little lapse in connection.
Oops.
Yeah, go ahead, Yvette. You're back on.
Okay, good. That same comment to the snitch rule provides that, see, I can't see that too well. Also provides that a report to the proper tribunal may also trigger obligations for the tribunal to report the misconduct to the state bar or to take other appropriate corrective action. So what that means in the context of arbitration is that if the report is made, of incivility is made to the arbitrator, or the arbitrator observes it in some way, that may trigger the arbitrator's obligation to report it to the state bar. It says may trigger. It doesn't say must, but it does say may. So an arbitrator is going to have to consider whether or not he or she can actually take care of the misconduct in some way or the incivility. But if he or she cannot, my reading of this comment is that that would be reported to the state bar. The arbitrator would have to do that if the arbitrator, him or herself, could not take care of it. There are exceptions to the snitch rule, by the way. I'll just go over, I won't read the rule to you, but basically attorneys and arbitrators and mediators are not required to report information or misconduct information that they obtain in connection with the attorney-client privilege or the mediation privilege. Alan, we talked about this earlier. If there's incivility during mediation, I think there's no way you can report that to the bar because that's something that would violate the mediation privilege or any other privilege for that matter. There's no obligation to report that under the snitch rule.
And you know what? And let me just stop there because I think that makes a lot of sense. Because part of mediation, it's being able to be open, being able to be yourself. Sometimes that comes across differently from other times, and to sort of sanction someone or bring something to the attention of the state bar based upon how an attorney acts in mediation, that's a little bit unfair, I think, because really that's the form of really being able to express yourself.
Absolutely. Absolutely. That's the interest behind the mediation privilege that still need to be protected, even in the context of this snitch rule. So the snitch rule does recognize that. The other circumstance that's an exception is when an attorney is undergoing treatment for substance abuse or mental health issues. And that makes sense too, right? Because we don't want to discourage attorneys from seeking help either for their drug abuse or for a mental health condition. We want to encourage them to do that. If they're afraid that something would be reported because of their to the state bar because of alleged incivility, that really discourages them from seeking treatment. So it makes sense. Also, if an attorney is consulting other attorneys about incivility or misconduct, that also should not be reported. That because the attorney is asking for help, right? Trying to wade through what is misconduct, what is incivility, what are my obligations. If you're doing that by reporting that attorney, you're defeating the whole purpose of this civility, right? You're turning them in, and really they're seeking help. So those are exceptions to the reporting requirement. And an ethics hotline, same issue.
That's fine. I have it now. We're going to change focus a little bit and talk about how courts have dealt with incivility. And you'll see there's been an evolution. And Yvette will talk about a lot of the earlier cases where courts have dealt with a lawyer not acting with proper decorum by either sanctioning that attorney, contempt. And there's been a shift. And the shift now is, and I'll talk about it, it's my favorite case, the Snoke decision, which I'll speak about in the end, where the court says, you know what, if you're not going to behave properly, I'm not going to judge you the same way as a lawyer of your experience level. So when it comes to attorney's fee motions, that could be a basis to lower the attorney's fees that you are requesting based upon your conduct throughout the litigation. So Yvette, if you would, please mention some of those cases where we talk about sanctions and contempt, and as we get closer to the Snoke decision.
Yes, absolutely. So what we're going to do here is give you examples of what's considered severe or substantial incivility and go through all the various consequences of the incivility that courts have imposed, all the way from, monetary sanctions, contempt, other types of punishment. And then Alan will talk about the attorney's fees issue. But we'll go through those cases. It's not every case, by the way. We just kind of categorize them. So it's not every single case that has ever addressed incivility.
There'd be too many to mention.
Yeah, unfortunately. Okay, our first category deals with false statements to the court and false accusations against opposing counsel as a basis for incivility. The first case I want to talk about is the case of Kim versus Westmore. That's a case where plaintiff's counsel asked and received an extension to file an appellate brief late. And the basis for the request was that I need more time to research the cases and finish my brief. I have too many time commitments. Well, in fact, when the brief was ultimately filed, the Court of Appeal found that the plaintiff's brief was essentially a copy of a brief he filed earlier. So it really wasn't it didn't reflect any new research or complex research of complex issues, and counsel could not have claimed any more significant time in preparation for that brief. So the court said his conclusory claims in support of his extension were, not to put too fine a point on it, untrue. We cannot overlook such conduct. It is critical to both the bench and the bar that we be able to rely on the honesty of counsel. Then, if you want to add insult to injury, the brief also accused defense counsel, the opposing attorney, of falsely arguing the case, calling the appeal frivolous, which it was not, and asking for $20,000 in sanctions without discussion of the facts or the law that would support, the claim that the appeal was frivolous or the sanctions. So the court just was not happy with that. The request for sanctions should be reserved for serious violations of the standard of practice, not as a bullying tactic. And clearly, that was what was intended in this case. And I want to read to you what was stated by the appellate court in that case, because it really is a warning for all of us and kind of a little lecture, actually. So let me read that. I like it quite a bit. It says a lot about us. Our profession is rife with cynicism, awash in incivility. Lawyers and judges of our generation spend a great deal of time lamenting the loss of a golden age when lawyers treated each other with respect and courtesy. It is time to stop talking about the problem and act on it. For decades, our profession has given lip service to civility. All we have gotten from it is tired lips, which I love that line. We have reluctantly concluded lips cannot do the job. Teeth are required. In this case, those teeth will take the form of sanctions, and the attorney was sanctioned $10,000 and referred to the state bar. The next case I want to talk about is similar in terms of the allegations against opposing counsel and litigants. It's Findleton versus Coyote. It's a Native American case in which the tribe, in its brief, accused the litigant of embezzlement and then accused the opposing counsel of having a known history of harassment and personal animus toward Native Americans, which was not appropriate, not true, and served no purpose other than to impugn the motives and integrity of an opposing litigant, counsel, and witnesses on whom he relies. And what's interesting in that case is the Court of Appeal had a discussion about how when they see those types of attacks on litigants and opposing counsel, they see it as an admission that your merits are weak. There was a whole discussion about that. And because of that, they're going to disregard your arguments because you have made an admission before them that you have a weak argument because you're attacking your opposing counsel unfairly.
It's a great point. Yes. So often it's the case where a lawyer believes that by his or her behavior, by being rude or talking down to another attorney or a party, that they're being intimidating. But in fact, what these cases are telling you is it's the opposite. They're just being a lot less effective.
So incivility in the form of false statements to the court and false accusations against opposing counsel will result in monetary sanctions, referral to a state bar, and potentially the disregard of all your substantive arguments before a court. Our next category of incivility, hardball, scorched earth litigation tactics. And the case I want to highlight here is actually a very severe example of incivility. It's Crawford versus J.P. Morgan. That's a case where the two attorneys were having a dispute over scheduling plaintiff's deposition. And what happened, they eventually came to an agreement for a date, but the plaintiff's attorney brought pepper spray and a stun gun to the deposition. And the attorney pointed the pepper spray at the opposing counsel and said, "I will pepper spray you if you get out of hand." And then he took the stun gun and put it close to the opposing attorney's face and then fired it close to his face, not at his face, but close to it. Just horrible, really, really severe hardball tactic, I will say. And the trial court got wind of it and imposed a terminating sanction against the plaintiff's counsel, basically dismissed the action. And the Court of Appeal affirmed that. And the Court of Appeal stated, if ever a case required a terminating sanction, this is it. Counsel made it impossible to continue with the litigation. Far from the trial court abusing its discretion, it would have been an abuse of discretion not to impose a terminating sanction. So that's in the nature of a very severe type of incivility, resulting in a severe sanction.
Because you also, by terminating sanction, you also open yourself up to a lawsuit from your client.
Absolutely. There you go. There's another malpractice, right? There's another outcome from that malpractice. In this case of marriage of Davenport, that's a family law case. There, the attorney used abusive, rude, and disrespectful language in letters, but also scorched earth litigation tactics over many years. And this had come to the attention of the appellate court. And the appellate court highlighted one particular letter where opposing counsel said of counsel said of opposing counsel this in a letter. We've noticed that in the past, you have some trouble keeping things straight. We also noticed that you tend to stretch things somewhat too far in the name of appearances. It's no surprise, then, that your letter appears to be an attempt to create a false and misleading exhibit for use at a later law and motion hearing so that your client can sit in court with a halo over his head. And so you can say how many times Ken offered to settle. That wouldn't surprise us at all, given your practice of attaching a large pile of exhibits to your declarations without any testimony from you concerning their truth. So you can see there's a lot of scorched litigation tactics being discussed, a lot of acrimony between the lawyers, and absolutely no trust and no respect going on there. The Court of Appeal says there's ethical violations there, violations of duty to your own client and the opposing counsel. The court found that the counsel's demeaning comments to the opposing attorney were contrary to the California Attorney Guidelines of Civility and Professionalism promulgated by the State Bar, and also closing the discussion with a reminder to counsel, all counsel, regardless of practice, regardless of age, that zealous advocacy does not equate with attack dog or scorched earth, which was what we saw here, nor does it mean lack of civility. Zeal and vigor in the representation of clients are commendable, so are civility, courtesy, and cooperation. They are not mutually exclusive. So the court affirmed sanctions of $100,000 and an additional attorney's fees of $307,000. So I think that statement that civility and courtesy and zealous advocacy are not mutually exclusive. They go together.
I'm looking through some of the questions, and one question strikes me, which I think is a great question that's worth discussion. The question reads: we have cases where procurators represent themselves and behave outrageously, threateningly, and the courts and family laws do little to curb them. Will these rules apply to procurators acting as their own attorney? I would say they don't, unfortunately, because these rules are meant for lawyers. Procurators are up to a different standard. And I think what you're left with when you deal with a procureur is bringing it to the attention of the court and having the court deal with it.
I think that's right. These rules are meant for attorneys. They are not meant for procureurs, and I don't think they will be applied to procureurs. But your trial judge should try some way of controlling the procureur. I mean, sometimes with procureurs, as we all know, sometimes it's better just to let them rage on for a short bit and then cut them off, but give them a little opportunity to say their piece. And once they say their piece, hopefully they'll be done. But yes, it is a problem, but these rules will not apply to those procureurs.
And Yvette, just for timing purposes, we're a little bit more than halfway through the program right now.
All right, I'll try to go quickly. So incivility in the form of hardball, scorched earth litigation tactics. The result will be terminating sanction, dismissal if you're the plaintiff, striking of the answer and entering of default if you're the defendant, substantial monetary sanctions, and attorney's fees award. The last category I want to talk about is abusive, aggressive, disrespectful language to the court, counsel, and litigants. First case I want to talk about is Mahoney. That's a case where the Court of Appeal was impugned. In a brief, an attorney filed a brief impugning the integrity of the Court of Appeal, basically actually stating to the Court of Appeal, our society has been going down the tubes a long time, but when you see it in black and white, as in this opinion, in this case, it makes you wonder whether we have a fair system. Accusing the Court of Appeal of judicial sleight of hand, telling the Court of Appeal it did not follow the law, telling the Court of Appeal you indiscriminately screwed my client, the petitioner. Well, telling the Court of Appeal you screw their client was not the way to go. The Court of Appeal found that attorney guilty of 2 counts of contempt and said, we published this decision as a cautionary tale. The timbre of our time has become unfortunately aggressive and disrespectful. Language addressed to opposing counsel and courts has lurched off the path of discourse and into the ditch of abuse. This isn't who we are. So in addition to the 2 counts of contempt, the attorney was reported to the state bar. In the case of Martin versus Vautier, this is a relatively new case. It's unpublished, but I highlighted it because it had a remedy that's unique. This is a divorce matter in which during the divorce, the court made a ruling against one of the parties, and the attorney for that party approached the opposing attorney's spouse and called her a lying bitch, and others in the courtroom heard it. And when the trial court got wind of that, it ordered the attorney disqualified from the case, and the appellate court affirmed that, saying, you know what, you're off this case, that's unacceptable. And the appellate court said, Rule 4.2 is not limited to communications made in the absence of the party's counsel. Rather, it applies by its terms to all communications made without counsel's consent. And there is nothing in this record to show counsel consented to the attorney approaching the opposing party and speaking to her in vulgar and insulting terms and in an angry manner. So there you have where, again, Alan, a potential malpractice action, right? Somebody began substituted out because of their misconduct or their incivility.
Absolutely. What's going to be with all the attorney's fees they charged up until that point? Is it going to be collectible? Is the client going to want their money back?
Very good point. Next case is also a recent case, 2024 case, Massimo versus Vanderpool. And this is a case where emails exchanged between counsel are nasty, and the court was not having any of it. This is the email. Counsel email to opposing counsel. You are joking, right? In 30 years of practice, this may be the stupidest things I've ever seen. Robert, is this really why you went to law school? Quit sending us paper. You know we are out of the case, so just knock it off and get a life. Otherwise, we're going to be requesting sanctions against your firm for even bothering us with this nonsense. Well, the Court of Appeal felt that that was the nonsense and said, civility is not about etiquette. It's not about a matter of bad manners. Incivility slows things down. It costs people money they were hoping their lawyers to help them save. Incivility is the adult equivalent of schoolyard bullying and we will not keep looking the other way when attorneys practice like this. They will be called out and immortalized in the California appellate reports. The $10,000 sanctions was affirmed in that case. The case of Claypool versus County of Monterey, this is a trial court case, but I wanted to bring it to your attention because it actually talks about the intersection between civility and bias. In that case, there was a deposition going on with a male attorney and a female attorney, and during the deposition, the male attorney said to the female attorney, move on with your next question and don't raise your voice at me. It's not becoming of a woman or an attorney who is acting professionally under the rules of professional responsibility. Oh boy, when the trial court got a hold of that, was not happy. Lawyers owe a duty of professionalism to their clients, opposing parties and their counsel, the courts, and the public as a whole. Those duties include, among others, civility, professional integrity, personal dignity, candor, diligence, respect, courtesy, cooperation, and competence. The practice of law before this court must be free from prejudice and bias. Counsel has stooped to an indefensible attack on opposing counsel. In that case, attorney's fees were awarded for the motion and the deposition, and interestingly, $250 to the Women Lawyers Association of Los Angeles.
Yeah, let me jump in on that one because I think that surprises me a bit because it's one thing to award sanctions and have those sanctions paid to the other attorney. It's another thing to order monies be paid to an organization as a sanction. What's your thought about that?
You know, I wonder what would happen on appeal if that had been appealed. We don't know if that's the case because this is a trial court case. It doesn't appear to have been appealed as far as I can tell. I'm not sure that would be upheld. I'm not sure there's any authority to do that, but this is what trial courts have done. If that's ever done, we'll see. There may be a challenge to it. But
let me do this. I'm going to switch focus a little bit since we are getting close to running out of time a bit. And talk about the Snow case. So Yvette spoke about sanctions, contempt, even a trial court being as bold as to order monies being paid to the Women's Lawyers Association as a sanction. And that another reason why that bothers me is that's not a sanction. That's something you should do voluntarily. The Snow case is a new paradigm. And actually, someone on the Civility committee actually emailed me about this case when it came out. It was originally an unpublished decision, and there was a big movement to get it published because it was so good in addressing what it means not to behave properly and how that should impact the lawyer's pocketbook. In Snow, plaintiff, it was a FEHA case, it was an employment case. Plaintiff was successful through trial on one cause of action, entitling the lawyer to attorney's fees. The attorney's fees in that case was over $1.1 million, which the courts found was reasonable given all the work that was done through these years of litigation. But the court exercised its discretion and reduced that amount by over $400,000 to $686,795. And what the trial court did is it applied a negative 0.4 multiplier. It basically reduced the fees by 40% based upon the lawyer's conduct throughout the litigation. And what the appellate court said is it appealed, it agreed with the trial court and said a court may apply in its discretion a positive or negative multiplier to adjust the lodestar calculation at a reasonable rate times a reasonable number of hours to account for various factors, including attorney skills. It's equating civility to whether the lawyer is acting with the skill that required to gain the result. The court went on. The record before us amply supports the trial court's finding that plaintiff's counsel was repeatedly and apparently intentionally uncivil to defense counsel and to the court throughout the litigation. The facts of this case are great. The court examines 12 emails that counsel sent to defense counsel, talks at length, 2.5 pages worth of the opinion, talking about 13 statements made that were bullying. And what the court said is that the trial court, and they agreed with it, noted that plaintiff's counsel incivility was not only directed to opposing counsel, it was also directed to the court. The court remarked that in a previous minute order that plaintiff counsel's tone of voice. It wasn't what the counsel said. It was the tone in which it was being said, which was not reflected in the court reporter's record, was both belittling and antagonistic. At times, it verged on the contemptuous. The court continued, plaintiff's counsel's ad hominem attacks were unnecessary for the zealous representation of his client. Citing case law, the court noted the absence of civility heightened stress and debases the legal profession. That's a big point. It's not only the fact that if you're going to act that way, you're not acting with the requisite skill level of someone with your experience, but it also makes the practice of law so much more difficult, which is really what these rules are trying to get at. We want lawyers to zealously advocate for their clients, but that you want to do it in such a way where you're fighting over the facts, not over each other. Going through the case, the court talks about how it lowered the lodestar, and it says a downward departure from the lodestar figure is justified where the attorney demonstrates that he is less skilled than would be expected of an attorney with comparable expertise or experience billing at the same rate. The evidence supports the trial court's implied finding that plaintiff's counsel presented issues with less skill because of the way that he behaved through his incivility than would be expected of comparably experienced attorneys charging $750 per hour who conducted themselves with civility. The trial court thus had discretion to reduce the lodestar figure based on counsel skill reflected by his incivility. It's a watershed moment in this regard. Even in arbitration, when you're looking at attorney's fees award, you're giving the trier of fact another tool to make sure everyone behaves the way they should. Because if you don't behave the way you should, not only is it looked upon badly, it can also impact the ultimate attorney's fee award if you are a prevailing party and are entitled to such award. I'm going to switch to, we have about 15 minutes left. And I'm going
Ellen,
to
I'm going to make a suggestion. Let's go
Please.
to our last part of our program, and because we already handed out these guidelines. Let's go to that last part.
I think that's a great idea. So what's in the material is an example of various superior courts have local rules which talk about civility, and it's talked about in terms of how you conduct depositions, how you assert your objections, how you give extensions of time. That was always such a stressful part of litigation. When I was a litigator, asking a opposing counsel for an extension and not knowing how that counsel would respond and whether they would try to gain a tactical advantage. So the LA Superior Court is a good example. I think if you look at the district court rules, you will find similar examples, and you look at other jurisdictions. It's the understanding that being an attorney does not mean gamemanship. Being a successful advocate also requires that you act professionally. We're going to switch a bit and just talk about some examples of incivility that we've experienced in practice. My best story, and then I'll turn it over to Yvette, was when I was a young lawyer defending a deposition. And I was very lucky in that case. I had discovery referee. And as I was asserting my objections, the much more senior lawyer was belittling me, telling me my objections were inappropriate, calling me names. And I filed a motion with the arbitrator that we had looking at discovery motions for us. And not only did he look at what I submitted to the arbitrator, he also looked at the entire record, and the discovery referee not only sanctioned plaintiff's counsel, but notified our trial judge. And I still remember the next time I was before another motion before that discovery referee, he mentioned the trial judge called him to thank him. Because even then, and we're going back 15, 20 years, it was an issue that judges and many lawyers were cognizant of. Trying to bully someone because they're younger, they don't have your experience, or because of their gender, which we'll talk about. That's something that's not conducive to the practice of law. Yvette, do you have any war stories that you'd like to share?
I have one in connection with being on the bench. It really wasn't incivility toward me. I guess it was dealing with incivility. I had a case when I was in the IC court where I think it was an employment case where one of the parties was having trouble in the deposition because the other party's lawyer kept objecting repeatedly with the same objections over and over and just could not get through, a decent day of deposition. And they were showing me transcripts saying, look, Judge, I just can't get through this deposition because of these objections. They keep coming in. They're unmeritorious. I just can't get through it. And so I said, okay, fine. They asked me if I would have them do the deposition in my chambers, not in my chambers, in the jury room. And I said, well, I really don't like doing that, but I said, this is pretty severe. They can't seem to get through it. I'll be available if you need me. So they came in, they had a court reporter, they're in my jury room, and sure enough, they called me in. I went in, okay, I have to make rulings on these deposition objections. And sure enough, the lawyer was objecting, harassing type of objections over and over. Finally, I got to the point where I was overruling the objections, but they didn't seem to stop the lawyer until I did this. I said, you know what, counsel? I'll make a deal with you. You can have a standing objection as to, whatever it was, relevance or whatever his objection. You have a standing objection. And am I overruling you is standing as well. So let's move forward. And for some reason that worked. So we kind of made this deal. You have your standing objection, no problem. You're preserved. Let's just move forward. And that somehow worked. So we didn't have to keep coming back and forth. So that was one way of dealing with it. But I have to tell you, I don't recommend doing that because judges don't like taking up their jury rooms and being in the middle of depositions when they're on the bench. So,
and you also don't have the resources to deal with it. I mean, that's an incredible example that you as a sitting judge went in and actually took part in their deposition to make sure that they were acting properly. Judge, even if a judge wants to do that, most of the time they don't have the time to allow them to do that.
Yeah, that's true.
Let me switch topics a little bit and talk about our current practice. So I do mediation and arbitration, so does Yvette. and we think about how incivility impacts our practice. On the mediation side, and I wrote an article about it, what strikes me is when I first started practicing law, when I went to a mediation, we'd always start with a joint session. I would give my opening statement, making sure that I would make my client's point, but not upset the other side to the extent to make settlement impossible. And now most of the time, me included, and my colleagues, I think share this, we rarely start with a joint session. And when we do bring counsel, the parties together, we oftentimes, unless it's very clear counsel's just getting along, we have rules. You have to listen to the other side. You can't talk over them. You have to behave professionally. And I always thought that, I started my mediations, and it's still true, because I want to build individual connections. So I separate the parties. But what I've discovered is part of the reason why I don't bring them together from the beginning is because of the fear that someone may say something to upset the other side, and which wouldn't be conducive to settlement. And it's another avenue where we don't even think about it, but civility plays a role. Yvette, do you have anything to say with respect to mediation?
I do, and not with arbitration, but I do with mediation. And it's kind of a quandary, really, for lawyers, I think. But this is a true story. The names have been changed to protect the innocent, right? Because it's mediation, so I can't really get into a lot of detail. I'll just give a short little synopsis of what happened. It's very quick, but it's a true story. I was in a mediation, and some bad news had been delivered to one side, okay? Because, they're communicating with each other, and one side was willing to disclose some evidence that they had, so it's bad news for one side. So I was there delivering the bad news, right, for one side to the other side, and we're all talking about it, all of us, the lawyers, me, the clients were there on that side. And I was about to move into, and it got a little bit heated. I mean, the discussion about the evidence was a little bit heated, but I was about to move into the other room. It was on Zoom, and I was about to move to the other room, and I heard the client say, there were two clients in the room. I heard the client say, "Whose side are you on?" So I stopped moving to the other room, and I said, "Excuse me?" I said, "Did I miss something?" I didn't know whether he was referring to me or his attorney. Either way, that was not civil, right? That was clearly a bad, uncivil way to deal with the bad situation. Now, interestingly enough, that didn't come from the attorney, that came from the client. So if the client was addressing me, that's horrible, but I could deal with that. But the problem was, what if he was dealing with his lawyer? I thought, no wonder these poor lawyers, they react because they get these horrible, statements from their clients, these horrible pressures from their clients. So I guess what I'm trying to say, it's not an excuse for being being uncivil, but it is an explanation for why it happens, that clients put horrible pressures on their attorneys. I'm sure many of you out there have experienced that, and that I think could be the basis of the basis for why attorneys act the way they do. Sometimes their own clients do that to them. True story.
Let me touch arbitration just for a second so we can move on and get through. I mean, in arbitration, my view is I think lawyers tend to act a lot more civil than they may act in trial court, because number one, it's a lot more expensive, but you're paying for the arbitrator's time. You're focusing in on the issues, and in the arbitrations I've done personally, I'm sure arbitrators will have different stories to tell. I personally have not seen lawyers acting improperly. I have seen parties act improperly. And the biggest issue is making faces during witness testimony and like. And what I always do is I always stop the proceeding right there to make clear what we're there for. And that is to present our cases and to be professional and to act with a proper level of respect towards the other side, even though you disagree with them. Let's move on to our next topic, which is, we talked about it a little bit about younger attorneys. Definitely true. Younger attorneys tend to get ramshotted, and they're the ones who experience incivility the most. I think it's also true, unfortunately, about certain female attorneys. I personally, I sat through a civility presentation. I wasn't on the panel for this one. where one of the lawyers said, in response to a senior partner at a big law firm, said, when one of my female lawyers gets bullied or when there's conduct inappropriate, I stick a male attorney in the room with her. And the reaction to that, me and other people there, was really like, a female lawyer doesn't need the male lawyer's help in order to combat incivility. I had dinner that night with a group of very senior, experienced female trial lawyers, and they were all outraged by that comment. And it shows that, part of the reason why these things happen to younger attorneys, female attorneys, is the fact that there is, unfortunately, still today an idea that they don't know how to react, and maybe an unfair advantage can be gained. Yvette, when you were on the bench, do you feel that lawyers treated you differently because you're a female instead of a male judge?
I think that happened more when I was a junior judge. When I first got on the bench, I think I saw a lot more kind of disrespectful type behavior. As I got older, more seasoned, so to speak, on the bench, I didn't see it as much. But as a young woman judge, yes, I definitely saw it. Definitely.
It's so unfortunate. And with our limited time, we have 5 minutes left. Let's talk about whether incivility has gotten worse through COVID and Zoom. And I guess on the one side is that, through Zoom, people, and you're at home, people are responded and are a lot more easier to misbehave. I will say on the mediation front, I don't know if that's true or not, because we don't do joint sessions as often. If someone misbehaves, I look at it as part of the process and helpful to get the emotions out. Arbitration's what I see, and I'm going to ask you about court trials. The problem I see with arbitrations is lawyers trying to speak over other lawyers because they're not together in the same room, and even that I find to be with a lack of respect and is somewhat uncivil. Yvette, what are your thoughts?
I think, well, with the court uses Zoom or Zoom type technology in the courtroom. And so when I was on the bench, I didn't really like Zoom that much, to be honest. I really don't like it. I prefer in-person hearings and in-person trials and all of that. I don't like remote, but I understand it's a savings for attorneys. But I do think that attorneys tend to act worse. I think there's worse conduct because of Zoom. I tend to see they're not with each other, or they're not in the courtroom, so they feel comfortable throwing little zingers at each other over the internet. I mean, that's how I view them. A lot of zingers, but they don't have to. They're not accountable. They're not in the courtroom, so they don't see the other side necessarily the same way, and they don't see the court the same way. We're just a little box on the screen. So I think it makes it worse. Actually, I don't think Zoom has helped at all. And COVID, I'm not sure COVID did anything, but Zoom doesn't help. That's my view.
I think that's right. I'm gonna read one of the questions that we've gotten, and to the extent we don't get to your questions, which we probably won't, since we're almost out of time, we will try to respond to you in writing at a later date. But one question, and it segues nicely to our next topic, is how do you recommend dealing with incivility from the bench to counsel during ongoing litigation, including while on appeal? Yvette, what are your thoughts?
General incivility, I mean, I'm not sure exactly what you're saying, but in general, I think the best thing to do, the best way to combat incivility is with civility. In other words, don't take the bait, basically. I mean, somebody who's acting that way with you is trying to get you to make a mistake in some way, whether it's in your papers or what you say or what you do. So the best way to combat incivility is to be civil yourself. I mean, I know that probably sounds easy to say and hard to do, but I think that's the best way to do. If it becomes a repeated problem or severe, then I think you should bring it to the attention of your trial judge in some way, and earlier rather than later. And make sure that when you do that, you're calm and collected. You have your ducks all in a row with exhibits or letters or emails or whatever. Make sure that you're calm when you present it to the judge too, because the judge, if you're very upset about it and very emotional in your presentation, the judge may think you're the problem. So make sure that you're nice and calm when you present your sanctions motion or whatever. Present the civility issues to your judge.
I think that's 100% correct. And it's funny when you said don't take the bait. I had written down my own personal notes. Don't fall for it. The worst thing you can do in the face of someone misbehaving, calling your names, yelling at you, is doing the same to them, because that's what they want you to do. They want you to lose focus, and your focus should always be on representing your client to the greatest extent possible. And when you're angry, when you feel slighted, when you feel like you have to get back on the opposing counsel, it also impacts your ability to represent your client. What I used to do when I was a trial lawyer, when someone yelling at me, which happened a lot, I would use silence. I would just stop talking. Eventually, the other lawyer would see I wasn't saying anything, and I would say, "I'm only going to speak when you give me the opportunity to do so." That sort of would lower the temperature and bring us back to the ultimate subject we were dealing with. I see we have 1 minute left, which is perfect because we're down to the final word, and I'll send it over to Yvette to sort of go over what we've learned today.
Yeah, I think this really sums up our civility obligations, and I'll read it. Thank you, Alan. There is no better guide to professional courtesy than the golden rule. You should treat opposing counsel the way you yourself would like to be treated. And that's directly from the Ninth Circuit. So that really should be your guiding light.
Thank you, everyone, for spending time with us today. I hope that you took away something from it. As I mentioned with the questions, we will try to respond to them at a later date.
Thank you.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.